how does a nursing home abuse lawyer go about proving negligence or abuse in a nursing home setting? That's what we specialize in. So I'm going to try to give you a condensed version of how we review cases and litigate these cases. There's several common injuries and complications that occur in nursing homes. The most common is the pressure ulcer. So I'm going to use that as an example just because that's the most frequent injury or complication we see due to nursing home negligence. The first step we do is we get the medical records from the actual nursing home. This may be hundreds or sometimes thousands of pages, depending on how long the nursing home patient has been there. And we're looking for specific sections of the nursing home record to match up to federal regulations. Nursing homes are one of the few healthcare providers that are federally regulated. There's regulations passed in the Omnibus Budget Reconciliation Act of 1987, and it's 42 CFR Part 493, and there's a long list of regulations. These are federal requirements that nursing homes have to meet in order to accept Medicare and Medicaid for payment for nursing home services. So nursing homes can get in hot water, can get in big trouble with the federal government or the state government for not following these regulations. These regulations really create black and white rules as to what nursing homes are supposed to do and what they're not supposed to do. So when we are evaluating any type of nursing home negligence or abuse case, we are trying to look at the records and see whether the care that was provided and planned for actually meets the federal regulations. And if it doesn't, you have a great legal argument that the nursing home violated the standard of care. And let's back up a bit. What does that mean? To prove any type of medical malpractice case, you have to prove that the healthcare provider failed to meet the standard of care or breached the standard of care. The standard of care, we tell people, is just the reasonable skill, care, and diligence that's to be expected of any decent nursing home or any healthcare provider. Alabama law requires us to have an expert witness who has experience in the nursing home setting to review the records and other evidence and come to an expert opinion that the standard of care was not met. So we get into the medical records and are trying to prove the standard of care was not met and that the federal regulations were not met. And evidence that the federal regulations were not met, of course, can be evidence, strong evidence, that the standard of care was not met. These federal regulations, like I said, are extensive, but in a very general sense, here's what they require. They require the nursing home to do what's called a minimum data set, MDS, which is an assessment of the patient to evaluate all of their needs for mobility, like do they need assistance getting to the restroom, their needs for nutrition, for hydration, for being repositioned in their bed. There's all these different things where a nursing home has to evaluate. There's check boxes, numbers 1 through 10. Basically, this MDS, or minimum data set, is designed so that when the nursing home gathers all this information, they can develop what's called a plan of care. And a plan of care is something the nursing home must do to make sure that the nursing home patient's needs, health, and safety are met. Once the care plan is written out, then the nursing staff has to go about in meeting that plan of care. And if they don't do a correct minimum data set, or they don't institute a plan of care, or they don't take the interventions needed to meet that plan of care, and that causes injury or death, then you're going to have enough evidence to prevail in a nursing home negligence case. We have a network of expert witnesses we work with, and they are familiar with these federal regulations. In addition to the federal regulations, there are things called F tags, and that's in a surveyor's handbook where if the federal government, the CMS inspector, finds that the regulations are not met, they will write them up with an F tag. And that's the equivalent, kind of like a speeding ticket, saying, hey, you're not meeting these regulations and this is what you have to do to fix it. So we spend hours and hours and hours reviewing these medical records, the plan of care. What are the activities of daily living? Are they repositioning the patient in their bed every 2 hours as is required so that they don't form a pressure ulcer? In injury cases where a fall happened, was the nursing staff properly assisting this patient to the bathroom at the time they fell and got hurt? There's various things you can pick up on the records, and the medical records are not the whole story, but they are the primary evidence, so to speak, in any type of medical malpractice case. The records can be wrong, they can be incomplete, but they are the most important because it's going to at least tell the nursing home story as to what happened during that admission to the nursing home. So if you can really point to something in the records that was either not done and should have been done, or was done but it was done incorrectly, then you're going to have great evidence to show that the standard of care was not met. So that's how we review cases, that's how we litigate them if we believe there's sufficient evidence, and that's how we recover compensation for those people who have suffered due to abuse or neglect in nursing homes in Alabama.